Well, good morning, everybody. Welcome back to school. I know many of you have already been back for a while. I know some of our friends in Portage County just recently started after the fair, but I know from all the feedback I have had or heard, you hit the ground running as always. So welcome to our office hours for school year 22-23. And we, like Dee Dee said, have quite a few people here. We didn't receive any questions up front. We are going to address a couple that we've had several comments or calls about this summer and already this fall, and then we'll just open it up. So, okay, here we go. Okay, today's topic. So these are things that we have heard quite a bit about. Service delivery when students enroll with an expired or missing special ed documents. Psych roles and responsibilities and use of other personnel for psych duties. Preschool at past age 6, whether a student can remain in preschool after the age of at age 6. And then we'll open it up for questions, because when we saw the number of participants, not everyone's on that signed up, we thought, and as we have been out and about, we've had a lot of questions, not unusual. So I'm going to let Dee Dee start off with the next questions.
All right, thanks, Helen. So the first question is around what happens when students enroll in your district and they have an expired ETR or an expired IEP or combination of both of those. And I've had the question pop up a couple of times this fall, asking if you can treat them as non-disabled students and wait for them to work through MTSS and then, have a referral. And I, because we've had this more than once, it makes me think that maybe there was a conversation or someone misunderstood some guidance at some point, and this is sort of being bantied around amongst directors perhaps, but we just wanted to be crystal clear and make sure that everyone has a thorough understanding of what the expectation is. And so first and foremost, in the answer about treating the student as though they were non-disabled is a hard no. And the reason for that is because if you go back to your responsibility under Child Find, the onus for referral, evaluation, and service to the student is on the district. And remember this language: if there is a suspicion, and even if there's not currently a suspicion, but there is information that could warrant a suspicion, then the district has to act on that. So let me give you an example. So let's say there was a student in high school, and that student was not on your radar as a student with a potential disability, but the student is absent for a week, and the attendance secretary or officer is notified by the parent that the student had a suicide attempt or had some kind of breakdown and was hospitalized, for psychiatric care. In that case, even though that student was not on your radar as a suspicion of disability, you now have information that could possibly warrant a suspicion, because that is something outside of the norm. It is something that obviously had a very negative impact on the student, prohibited the student from attending school, student was hospitalized, et cetera, et cetera. That is not to say that that is automatically a suspicion of disability, but what it does say is now the onus is on the district to do some information gathering and at least consider, at least have a conversation, at least look at what information you have and consider whether a suspicion is warranted? And the answer could very well be no, could be simply a temporary or even a mental health issue doesn't always constitute a suspicion for a disability, obviously. But my point is even having information that could warrant a suspicion places the onus on the district. When you have a student enroll, it doesn't matter if their IEP or their ETR is expired by 5 years. You have knowledge that that child qualified as a student with a disability, whether it's current or previous, unless you have documentation that they were exited from special services, then you have to act accordingly. So that means you have to provide services. So what should that look like? Well, if they have an active IEP, but the ETR is expired, then obviously if you accept and adopt that IEP as is, you're going to implement it and you're going to begin that evaluation process, as soon as you're able to. If you aren't accepting that, then you're going to go and amend it as appropriate, or, write a new one, whatever the case may be. If you've got both expired documents, then of course you can use that NIEP as your EMIS code. That's your placeholder so that you still get funding and you are showing that you are serving the student, even though the student does not have an active IEP. So, and sometimes we're asked, well, what if that IEP is a couple of years old because they were out of school, they were at home, who knows where they were? Then you're providing services as best you can, aligned to that IEP in the best way that you can until you are able to complete a reevaluation and write a more appropriate IEP for the student. And I know you know this, but just a reminder that whether it's an initial eval or whatever the case may be, certainly when a student's coming in and they've got expired documents, you cannot refuse or delay the evaluation due to providing MTSS and RTI.
Questions? Okay, I take that as nobody has any questions. So
Okay.
I have a question. It's
Okay.
Liz from Green. You said that if we have an ETR that is expired,
Mhm.
we can accept that IEP with an expired ETR?
You can, because if the IEP is current, there are instances when an IEP was written and the ETR expired after the IEP was written. And so, yes, you can still accept that IEP if it's appropriate. And this wasn't a question, but since you brought it up, I'm just going to throw this out there. There is sometimes a misunderstanding that folks have that whenever you do a reeval, you must write a new IEP. That's not true. If the reeval happens and the IEP is only 3 months old, what you must do is you must consider whether any information in that reevaluation has an impact on the IEP and you need to amend it or not. Is there new information on the new evaluation that requires you to go back and change anything in the IEP? It might not. And if it doesn't, that's absolutely okay. There is no rule that says that every time you do a reevaluation, bam, you've got to write a new IEP. That's not true. And like I said, you have to consider whether or not you need to, or whether or not you need to tweak something. You may need to just amend the IEP a tiny bit, and that's fine. Or you might not have to do anything at all. And I've heard some folks express confusion around that. And again, that wasn't a question, but since you brought that up, I'm just throwing it out there. So hopefully that answers your question.
Yep, thank you. We've had, and the only reason I'm saying this is like perfect, we have had like over 30 move-ins this summer. It's been insane.
We're hearing that everywhere.
Oh my, and they're from all over the place. I mean, like
I know.
California, Delaware. I'm thinking,
Yes.
what? And just getting documents.
Yep.
I mean,
I know it's hard.
We have just an IEP and no ETR. We're like, okay, well, we're providing services and then we're reevaling. We're doing a reeval.
That's all you can do.
Yep.
And we are hearing this repeatedly about the mass influx of students. And what I'm going to
Yeah.
tell you is during the shutdowns and during COVID, many families pulled their children from public school and opted for online, or they homeschooled, or they did, any one of a myriad of things. And so now what we are seeing is this huge influx of students enrolling. So we know of districts who literally after the first day of school had, 30 students enroll all at one time. So it's happening everywhere. And as you said, coming from all over the country, because obviously in the change in way people work, people are moving, it's happening everywhere. So you're not alone in that.
Thank you. That helps. Thank you.
Okay, so we've had several questions pop up over the last couple of weeks concerning, I'm just going to be brutally honest and say what it's really stemming from. We have a shortage of school psychologists. We all know that was going on even prior to the pandemic. And so we know that districts are feeling the pinch and trying to figure out how they can best utilize their psychs. And so some questions have popped up around that we really think we need to address, because we want to make sure that everyone has a clear understanding of what is and is not allowed, and certainly what would be expected as well as best practice. So the first thing we keep getting asked about is it necessary to have the school psych at the ETR meeting? And then the second part of that is, we've gotten a lot of questions around, can staff without that psychologist license complete testing? Or we've even been asked if a district can contract with a clinical psychologist to perform the duties of the school psych. So we're going to talk through those right now. In terms of having the psych at the ETR meeting, again, we're going to refer you back to the operating standards and that language about having the meeting made up of a qualified team. Well, what constitutes a qualified team? Remember, it has to include someone who is able to analyze, interpret, and explain the assessment results, the educational needs, and the implications for instruction. We're going to be really honest and say that a district would be extremely difficult for you to convince ODE, or for that matter, a judge, if you were in due process, that did not require the presence of the school psych. None of the rest of the folks, generally speaking, on that team are going to have the knowledge and the expertise around those assessments for evaluation that the psych does. We may all have had a dabble in it in college, but we don't practice it. Your intervention specialist, your all the other folks in the district, none of us are doing that on a daily basis. So you would be really hard pressed to convince someone that you don't need a psych at the ETR meeting. So we're just going to say that is not a good practice. If there is a problem with scheduling, we suggest you get creative in rescheduling, doing things remotely if that makes things easier. You can have the rest of the team in person and have, Zoom the psych in, or have the psych on speakerphone if you need to do that. We understand that psychs are sometimes serving more than one location. We know that. So again, we're going to recommend that you just get creative with how the psych attends, but we strongly urge you to not move forward with meetings without the psych present. And Helen made a good point. Even if it's a reevaluation, if there was any new testing or anything like that, you are going to want the psych there. I suppose if you were doing a review of records and there was no new testing, and so that's information that's already been hashed over and explained by the psych, you could probably get away without having the psych present. But even in that case, I would at least have the psych reach out to the parent ahead of time to see if there was any questions, if there was anything that needed clarified, and make sure that the psych connects with the family in some capacity, even if it's just a record review, just to cover your bases.
Exactly.
All right, so the next part of that is that question that we've had a couple of times now about having contracting with a clinical psychologist to come in and assume the duties of the school psych. And I guess in short, what we would say is your school psych can't hang a shingle out at the end of the road and set up shop to provide psych services to the community. Those licenses are not interchangeable. The school psych does not have the certification or the license to serve the community at large, and neither does a clinical psych have the license to serve in a school. They are not licensed and certified by ODE, and so it is not appropriate for you to utilize a clinical psych to perform the duties of your school psych. It's also not appropriate for other personnel in your district to be conducting the assessments, because as we mentioned before about why the psych needs to be at the ETR meeting, we're not trained. Helen and I are both intervention specialists with, we're not going to say how many years of experience between us, because we like to keep that a secret because we don't want to age ourselves. But it's many years. And we're still not qualified. Are we familiar? Do we understand those assessments? Yes, but we are not specifically trained, and we do not on a daily basis practice the administration, scoring, and analysis of those assessments. And unless you are a very rare district who has the luxury of having someone who's not a psych in your district who does have those skills and that certification, you can't do that. You shouldn't be doing that.
Or if you happen to know someone like I do, and Dee Dee does, that has both certifications.
Correct. Yes, exactly. If they have, dual certification, but still they've got that license by ODE as a school psych. So you may be feeling frustrated saying, okay, Dee Dee and Helen, I hear you, but what do you expect us to do? Well, what we're going to suggest is that you try to adopt some other ways that you can address the shortage you may be experiencing or the time constraints for your psych by utilizing a psych assistant. Or it can be other personnel. It doesn't have to be someone with that official title, but I can just tell you in districts where they have a psych assistant, they are able to operate much more fluidly, and they aren't suffering some of the pains that some of the other districts are, because that person or persons can help with some of those clerical duties. They can certainly conduct observations, but that frees the psych up then to focus on the assessments and the report writing. So we would encourage you to move in that direction, as opposed to not having an ETR meeting with a school psych present, having an ETR meeting without your psych. We don't want you to do that. And, certainly not opting for contracting with an outside clinical provider.
Questions?
I have one. It's Liz again.
You're not a question this year.
You're glad I'm on, right?
Yes.
All right. We've had all these move-ins, but we've also had a large number of kiddos go on scholarship this year.
Mm-hmm. Oh,
And I know at least of one provider that they hire their own psychs to do the ETRs.
yes.
So
Okay.
what's our obligation? Because we're not doing the ETRs. The school district, so to speak, of the provider does it, but then a lot of these schools hire their own psych.
Right.
If they are not a school psych with a license and they're a clinical psych, what do we do with that ETR?
That, again, that's not your responsibility. That's because if they're on scholarship, that's the responsibility of the district where that provider is housed. And so
Okay.
that onus is on them and not on you.
And it can't come back to bite us?
No.
Okay, just asking.
Yeah,
that's good.
That's fair.
Yeah.
Okay. Because I know that's a fact for at least two that I know they're clinical psychs.
Sure.
Mhm.
Yeah. And
Okay.
again, there's nothing that you or, any other
Okay.
public district can do about that. Unfortunately, they do what they want, and we don't really get to have a say in that. So,
Yeah,
but
okay.
again, that onus is not on your district, but on them. So,
Okay. All right. Thank you.
yeah. Okay, so our last question, as Helen mentioned earlier, we've had a couple of questions around preschool children, and when they must exit preschool and enter kindergarten, if they must, when, and then what is the district's responsibility in those situations. And I suspect, again, it's been a rough couple of years, and you think about, the classification of, they're calling them COVID kids, but very young children who have not benefited from any kind of social interaction because they were, sequestered and for such a long period of time during that early development. So we are seeing, I would say, more than what is usual of students staying, or parents desiring for the student to stay in preschool for an extra year as opposed to moving on to kindergarten. So I'm going to just show you from the operating standards what the language is. So obviously, if the child is eligible for kindergarten, and we all know that that's at age 5, and it's whether your district opts for August 1st or September 30th, that, that's the age in which they can and probably should, for most kiddos, enter kindergarten. However, if the child turns 6 past that date for your cutoff, then they are in fact eligible to remain in preschool for the remainder of that year. Now, does that make them a very late, sort of older kindergartner? Yes, it does. And obviously you're gonna determine on an individual basis with your families if it's appropriate for the child to stay in preschool, or, in the child's best interest to move on to kindergarten. But the law does allow that they can stay. The two additional pieces of information that you see are that the team has to at least consider school age services during that IEP process if the child will be eligible for kindergarten. You have to at least have that conversation. You have to consider school age services. And then that second one, the double I, is just simply a reminder. This isn't a qualifier. It isn't saying that that this is a restriction. It's simply saying, as a reminder, that if the student in question is under the category of developmental delay and they turn 6 during the school year, they have to have a reevaluation prior to age 6 to determine their eligibility, because remember, you cannot carry forward the category of developmental delay. They have to meet the criteria of one of the other 13 categories. So that's just a reminder. So in a nutshell, they can in fact remain in preschool, and if they turn 6 after. So if they're kiddo with an October, November birthday, they can stay in preschool for that extra year. And then we've also had the question about, well, then what is the responsibility of the district if that's the case? And if they're eligible for preschool, then you are required, if they're a student with a disability, then you're required to provide that. obviously for most of you who are operating preschools in your district, it's going to be in the best interest for everyone for the child to be there where they can socially interact with the peers that they're going to move on to kindergarten with. You have closer eyes on them for purposes of reevaluation, all of those things. But if for some reason, that's not possible, or that's not the child's LRE and they need to be elsewhere, then yes, you are still responsible for that as well. So I think that's, unless Helen has anything else that we didn't think of, that's everything that's been popping up for us over the last couple of weeks. And we can turn it over to you now for questions, and you can let us know if you prefer that we stop the recording at this point, or if you're comfortable with us leaving that on.
Yeah, I don't have anything extra at this time. There are some still unanswered questions out there on various things. And got questions into the state for some updates. So, but go ahead and ask away and we'll see what we can answer.
We're educators, so we'll do our wait time.
Hi, my name is Ashley Graham. I'm a school psychologist. I was curious about dates, like planning form dates and consent dates. So I'm running into issues where I'm talking to a parent on the phone and saying, okay, I'll send this home and, sign it and then send it back. And they maybe don't send it back for several days, and then the dates aren't correct based on when I talk to them. So I just didn't know what I needed to do with that. Like, should I document that in a prior written notice? That sort of thing.
Great question, Ashley. And actually, you reminded me of something else that I thought I should probably address around the psych, some of the challenges with districts with the psych. So that's a great question. And yes, I would certainly document that in a PR01. And OEC has consistently said that you can time and date stamp something of when it arrives in the district. So they have in selective reviews, they have consistently said that. So you can, when something comes in, whether it comes into the front office, you can have the administrative assistant put a date stamp on it. This is when it was received in our district, because it got sent back in the student's backpack or whatever the case may be. Yes, you are allowed to do that. And then you can use that as the date that you received consent. So hopefully that answers your question. And if there's a big gap, then yeah, you can absolutely, just sort of note that in the PR01 that it was sent home on such and such a date. And again, that time and date stamp of when you got it back, but that's the date that you're going to use as your date for consent, is when it arrives in the district.
Okay, thank you.
Yeah. And actually, Ashley, you just reminded me of something that I did want to talk about, because Rachel Underkoffer, one of our colleagues here, she has had this come up a couple of times as well as I have too. And that we've heard that some districts have adopted a practice, and this is intended not to be judgmental. I'm just sharing with you ways that you might want to think about this and why you might want to think about it differently. Where some districts have adopted a practice of they get consent, they're doing their referrals and consent for evaluation, all of them at the beginning of the year. So they're looking at everybody that needs a reevaluation for the entire year, and they're getting all of those things signed and consent given in October. And that may seem like a good idea, because you're thinking, well, then we don't have to go through the hassle and the rigmarole of doing that as it comes up. But the things that I want you to think about are these. If you do that, there could be more current information later in the year in February that wasn't considered at the time when you got the consent. And the whole purpose of special education is that it's individualized. That is our call to action under IDEA, that is individualized. And saying we're going to get, we're going to make all our referrals, we're going to get consent for all of our evals in October for the entire year, it looks and feels like an assembly line production. And so it takes away some of that individualization and puts a sheen or a gloss on it that definitely feels more like we are stamping these out on an assembly line. And that does not look good to the state. And so we would just encourage you that if that is a practice that your district has assumed or is considering, that you might want to reconsider it just for those reasons. So thanks, Ashley, for your question. That just kind of, I know it wasn't exactly related to that, but thinking about dates and timelines just prompted me to remember that I did want to mention that.
You have any other pressing questions out there? I'm sure there are many.
Hi, this is Janelle. I have a question about transfer ETR and IEP timelines. As far as, is there like a hard and fast timeline with adoption or rejection of those documents, as well as the reevaluations that might be needed for the rejection of some ETRs?
Great question. So you need to determine whether you are going to adopt and accept within 30 days. So the 30 days is just for you making that decision. You do not have to have anything completed in terms of amending or writing a new evaluation or IEP. The requirement is that you make a decision within 30 days. Now, obviously, you're going to do it as quickly as you can so that you can best serve the student. It shouldn't always take 30 days, but if you've got 40 kids moving in at one time, it could. And that's why that provision is there. We often get the question about reevaluations, when do they have to be done? And I've heard a lot of people have, again, a misunderstanding that who knows how it got thrown out there, but that you have 60 days. And that's actually not true. There is no exact timeline for a reevaluation. However, the reason I mentioned just a moment ago about it's not a good practice to get all of your consents and everything all at one time at the beginning of the year. And I said it makes it sort of feel like an assembly line production. It also is sending a signal that, whenever we get to these reevaluations, that's okay, anytime within a year. What the operating standards say is in a timely manner. We are asked all the time, Helen, Dee, what does that mean? What's a timely manner? Well, we can't give you a clear definition of what a timely manner is. And when we've spoken to the folks at the state about that, their response is this, and it makes sense. They're not constricting you to 30 days or 60 days because there are circumstances that may warrant it going beyond that, and they understand that. But if you look up the definition of timely manner, it's pretty clear that that wouldn't mean any time in a 365-day period. Timely manner is as quickly as you are able to do so. And so, I just wanted to throw that out there again, because as you said, there are frequently questions about what is the exact timeline. And that's one that pops up a lot too for a reeval. Do we have 30 days or 60 days, to do that? And again, not a hard timeline, but you need to be doing it as quickly as possible. Again, when you think about what's the ultimate, the end reason for that, it's so that we can adequately provide meaningful services to the student.
And I'll just add there that I often get many parent calls about that exact same question. And they do mention 30-day timeline, 60-day timeline. So you are dealing with parents that, want to see it done, as proficiently as possible and want what's best for their kids. But I do often receive many phone calls on that exact same question. So,
Sure.
yeah.
Thank you. And when you said the 30-day, making that decision within 30 days from, as far as adopting or rejecting the ETR and IEP, is that 30 days from date of enrollment?
Yeah, from the time that they enroll. And I know that that's really difficult
Yeah.
sometimes when the kiddo enrolls and you're lagging getting documents from the sending district. I have been there as an administrator myself. I completely understand how frustrating that is. And the best advice I can give a district is have a policy and a procedure firmly in place for how you're contacting that sending district, making those requests, and then I'm just going to say it, your hounding procedure, how you're going to keep hounding them until you get something, even if it's they scan it and fax it to you. But you need to have like a policy and a procedure in place, because it is sometimes very challenging. And I'll just say, especially when you are talking about some community schools or charter schools, or scholarship providers, and a student's returning back to a district, it can be really taxing trying to get the documentation from some of those entities. And I know that. So do the best you can. And again, if you don't get something within the 30 days, then kind of go back to that very first question at the top of the hour where we said, what do you do if you have a student enroll and you don't have documents for them, but you know that this is a child with a disability? You provide services to the best of your ability, making the best decisions that you can with the limited information that you have until you do have more information. And if if you don't ever get anything, then you're going to proceed with, hey, we've got to evaluate this kiddo because we don't have anything to go on. So hopefully that helps.
Yeah, and with Dee Dee saying that about the policy and procedures, that just protects a district similar to a PR1. The fact that you have that in place, and say somebody was to be in a review, and like I'm saying, reviews are not punitive anymore. Maybe a long time ago they were, but the state is really, really working with districts. I know it's a pain to go through, but they would probably say, check, they had a policy and procedure, blah, blah, blah.
Yeah,
So
these are the steps you're taking to get, to get those documents from the sending district. And yeah, you've got, as long as you've got procedures in place, you're following that, you're documenting your attempts, you're trying to get that information. And then, like I said, if you don't get it and you've done your due diligence and it's not coming, then you do have knowledge. Like I said, that first question from the top of the hour, you have clear knowledge that this was a child who at one point was eligible for services. So you need to then act accordingly and follow your process for, evaluation.
Thank you. That was helpful.
Sure.
thanks.
Dee Dee and Helen, it's Kelly Kemp.
Hi,
Good
Kelly.
morning.
Good
Hi.
morning.
I'm sorry that I missed the very beginning because I was coming from another meeting, and you may have already said this, so I apologize to others if this was already covered, but kind of related to some of the questions that have been asked most recently. Something that we feel like we have discrepant information is if a student comes back, re-enrolls back in the district and had an IEP at one point, maybe did the scholarship, went to a private school, and let the ETR lapse, we reached out, did child find, they didn't want another IEP, but now suddenly their non-pub is a provider or something like that, and they, they want it again. So when we're getting those requests, or if we know of a student who had a previous IEP or, eligible for services previously, we're treating that as a reeval, even if it's expired, like past the 3 years, versus starting as an initial. And we've gone back and forth about that, and we feel like there was maybe some information that was coming out, but we didn't get clarity. So anyway, I thought I would ask. Maybe you
Yeah.
already discussed it, sorry.
We did discuss it, but you
Oh,
brought
I'm
up
sorry.
no, that's okay, Kelly. You actually brought up a nuanced point of that I didn't address, and that was how you're coding it. From the standpoint of serving the student, what I said at the top of the hour was you have clear knowledge that this was a student who was eligible for services, who was determined to have a disability. So you can't treat the child as though they're a non-disabled student enrolling in your district, and we're going to wait to go through MTSS and, see what happens. And then we'll think about, referring. You can't do that because you clearly have background knowledge. So from the standpoint of how you're going to serve the student, you would approach it as a reevaluation. But I didn't clarify this at the top of the hour, and I should have. The state did clarify last year because they changed their position. We had been given guidance on how we code something as a reeval versus an initial several years ago, and we even had it in writing and dated, and they changed their position on that last year. We have now been told last school year that every time you've got an expired ETR, it doesn't matter if it's from in-state or from out of state, it is an initial ETR. So you are entering it as an initial. What I was talking about at the top of the hour, and this speaks to what you're asking about as well, Kelly, I gave the example of the onus is on the district, even if you have information that could warrant a suspicion of a disability, even if somebody wasn't on your radar, but you found out, by the attendance secretary or by happenstance that, there was something going on with a child that you weren't even aware of, and you haven't been asked, a referral hadn't officially been made. But if you have that information, then at minimum, the onus is on the district to follow up with that and do a little bit of investigating and determine whether or not there's a suspicion and whether or not a referral is necessary. You have to at least act on it in some way, is what the court says. So you can't just say, oh, nope, we didn't have a referral, but they say, yeah, but you clearly knew that the student, was hospitalized for 2 weeks and was out of school under psychiatric care. And there was, a diagnosis of bipolar and yada, yada, yada. And you did nothing about that. So that was the point that I was making early in in our office hours today, that places responsibility on the district. And the same is true, as I was saying, that child was a child who was eligible for services. So you can't go back and treat the child as a non-disabled student enrolling. But in terms of, you brought up a great point that I failed to mention of, are you looking at it as a reeval or an initial? And I should have said that. So thank you for bringing it up. Anytime the ETR is expired in Ohio, out of Ohio, doesn't matter. It's coded as an initial ETR.
And did change.
And that did, that was a big change.
So I think that's where our discrepancy, like some of the stuff we had still said the other way, and I felt like we had heard it and we were like, wait a minute. Okay, so thanks for clarifying.
Yeah, you're absolutely correct. Like I said, we had it in writing, time and date stamped, and the person that gave the guidance. And then, we were hearing a lot of mixed signals last year. So we went back to OEC and said, okay, you've got to come out with a hard line on this because there's a lot of confusion. And so they said, in no uncertain terms, it's an initial whenever it's expired. So we can all move forward with that. And, and unless somebody changes it again.
I understand.
Follow up because there was a time when that
wasn't the case. Yeah.
And I said, wait a minute, even in Ohio. So anyhow, yes.
Well, that was helpful. Thanks. Yeah, we were having this big discussion debate. One of us was convinced it was one way and one was convinced it was the other way. And then I saw the note about it was going to be covered. And I was like, of course, I probably missed it because I was running late. So anyway, thank you. I appreciate it.
That's all right.
And quick follow-up question on that, with them being treated as initials, the district should be completing the referral form, is that correct?
Yes.
Okay.
Yeah, I would complete the referral form, but obviously in your PRO1 and everything, you're going to be making the case that you have knowledge that this student was already identified as a student with a disability, was already receiving services. So, yeah, you're doing the referral just because you're treating it as an initial. And that's what I said. It kind of muddies the waters. It's coded as an initial, but from the standpoint of how we approach it, it really is more of a reeval, because we already know that the student was eligible. We already know that this was a student who was receiving services. It's just a matter of the documentation has expired. There was obviously a lapse and there wasn't follow-up. And that can happen for a myriad of reasons, but sometimes kids drop out of school and they're at home, or we don't know where they are. Or sometimes, as we've mentioned, they've gone to community schools or scholarship providers, and things fall off the radar. So, but yes, so I would include a referral. I'll be honest, I think if you didn't have that and you were just acting strictly as a reeval, I don't think you would get called out on that by OEC, because you're following proper procedure. You are ensuring that you are evaluating this student and moving forward so that you can provide services, not dependent upon a referral as an initial eval. So I think you would be okay, but obviously in terms of when you're entering it into the system as an initial, the system is going to be looking for all the pieces of that, and that would include a referral. So that's why I'm saying yes, I would include that.
Thank you.
Any more questions out there? Besides, where do we get staffing? I'm sorry, I had to throw that in because that's been coming in a lot too.
And we are actually going to talk about that a little bit during our special ed forum, which is next week. So hopefully we hope that many of you will be able to attend. If you're not able to attend, remember that we do always record that and send it out usually within a day. I try to get them out the next day. So we are going to be talking about staff shortages and who you can utilize for what purpose a little bit on, I believe it's next Tuesday, right,
Yeah,
Helen?
it's the 13th, and it is a Zoom. It
Yeah.
is virtual, 9:00 till 10:30, I
Mhm,
think,
yep.
because we are Zooming in Amy Szymanski again for particular questions on alternate assessment
And
and
graduation.
graduation.
Yeah.
Because things change there too.
Yeah, so hopefully you can join us for that. And if not, as I said, remember that we've got that recording available to you. And I see we've got, oh, thank you so much, Rachel.
Hey, Rachel.
Rachel just put the registration link in the chat for us. So thanks, Rach. Yeah, if you've not yet registered for forum, we encourage you to do so. And hopefully we can see you there. We know that there's a big dyslexia conference at the
Yeah,
same time. So
right.
we understand if some of you are not able to be there, but hopefully you can. So any other questions before we wrap this one up today? We're so glad that so many of you were able to join us this morning.
Exactly. Rachel, do you have anything to add while you're on here?
No, I just think a lot of these are very pertinent questions. I was getting more contact form submissions to me just yesterday and today with some of these same questions. So if you can come to special ed forum next week, we have a lot of updates and information that we are going to be sharing. That's very timely. And so that might answer a lot more questions that are out there. But Dee Dee and Helen, I trust you and have full faith in all of your abilities to answer all the questions that come through. So thank you for all you did today for the slides and everything.
Thanks, Rachel.
Rachel.
Glad you were here.
Yes. Okay, we still have a little bit of time. Anybody else want to throw anything out there, or just even ask anything of your peers or colleagues that are on this call that, might help you out in any situation.
Hi, this is Kim. I just wanted to, in reference to getting signatures and other things, our district has gone to online signatures.
Many have.
And it's very, very helpful. As soon as you get off the phone, you send it an email and you have your signature back the same day for the most part.
Yeah.
If any of the other districts move to that.
That's a great point. And you know, the one thing we will say, if you're doing email signature, you know, you want to make sure that it's time and date stamped and that it identifies the relationship of the person who's providing consent. Make sure that it says, you know, I, you know, Susie Q am the mother of, you know, Jonathan, or whatever. Another thing that Helen and I have suggested often is in terms of getting signatures during the meeting. If your district does not have that capability, where you've got, you know, sort of the DocuSign or the being able to digitally sign, or if you're doing the meeting remotely, you can very easily over Zoom get a signature using the whiteboard feature in Zoom. You can also do the same thing in Google Meet. And on our website under special ed, Helen and I have about a 5 to 6 minute video where we demonstrate how to do that. So there are lots of options now for getting signatures other than face-to-face wet signature on a paper. So thanks for bringing that up, Kim. That's a great reminder. And again, as I said, we've got that short sort of tutorial to show you how to do it over Zoom if you want to get, you know, signatures in that way as well. And we have confirmed with the state that those are all acceptable.
Right.
Where is that tutorial, Dee Dee? It's Liz.
If you go on our website under
Okay.
special ed,
Okay.
you'll be able to find it there. Let me know, reach out if you have any difficulties with that. But yeah, it's, or if you go to our YouTube channel, it's on there as well. Like all of our office hours, we record them. They're all on our YouTube channel. And so are some of those additional tutorials, like the one we did around alternate assessment, decision-making tool, how to get signatures over Zoom. Those are all available on our YouTube channel as well.
Okay, thank you.
You bet. All right, any other questions?
We once again want to say, please feel free to reach out to us at any time. I mean, we do these office hours and we have form, but we also know that things come up all the time. So definitely reach out to us by email or phone, and we'll get back to you as soon as we can. And we want to say once again, have a great year. Hopefully things get a little less stressful.
Absolutely. And again, we want to say a big shout out and thank you to Rachel, our other special education colleague.
Yeah.
Rachel dropped in the link to our YouTube channel in the chat. So again, if you're interested in going back and checking out any of our videos or recordings from previous office hours, and oh, look, Rachel's fabulous. Item number 18 is the video I mentioned on digital signatures. So that makes it really easy for you. You can use that link to go to the YouTube channel. And yeah, number 18 is the one on getting digital signatures. And we heard from multiple districts last year or after we did that, that they have utilized that and it's very easy and works well. So that's definitely a great workaround for getting those signatures.
Yeah, I don't think I'm on that YouTube anymore because I think my signature was, you couldn't read it.
It was great. And again, it doesn't matter why
if you can or not.
It doesn't matter. It doesn't matter how pretty the signature is. It's acceptable.
Except for
So
Dee Dee wanted it to look pretty.
all right. Well, thank you, everyone. We hope you have a great rest of your week and weekend coming up. And we look forward to seeing many of you next week on Zoom for Forum.
Yes, thank you so much.